Thanks, Scott. Okay. Pick up thing. Now I'm always going to, oh yes, I can watch it down there, can't I? Okay. Come on, come on. Oh, gotta use the right button. There we go. If you recognize the castle in this picture, it probably means that you've been watching the TV series Downton Abbey. This building is called Highclere Castle. It's located in Hampshire, England, and it's used as the setting for the TV show, the TV series. Now, I think everyone would agree that whatever the precise contours of the phrase heritage building might encompass, this building would certainly fall into the category of a heritage building in most people's minds. What I like about this building, though, is that it's privately owned, and the owners have taken advantage of its obvious heritage aspects to turn heritage into something commercial. So there's a huge contingency of people who love to see heritage buildings like this. So among the things that members of the public can do now in this building for a fee are, A, you can rent the premises to make TV shows. B, you can rent a cottage on the grounds to have a vacation. C, you can hold a wedding or engagement party there. D, you can hold a corporate retreat or other event. E, you can just come for a day and take a tour. F, you can enjoy fine dining there. Or G, you can see one of the traveling museum exhibitions that are held in this building occasionally. But my point is that there is a demand among human beings for heritage architecture to look at and walk through and admire, and there is a voluntary, non-coercive manner to fulfill that demand as exemplified by this castle. But unfortunately, there are many people here in Canada who also love heritage architecture, and they want to share their love of old buildings with others, but they don't want to look for voluntary methods of doing this. They want to rely on force, the force of the state and the force of law. Property rights are a provincial matter according to Canada's Constitution. So every province has different rules on this, but we at the CCF have been dealing with a case in Ontario. So that's the province whose laws I'm going to talk about today. Sorry that I couldn't take the time to research Alberta's laws, but I know that every province, or I think every province has something similar in its panoply of statutes. But Ontario's is particularly problematic. And since about 40% of the country actually lives in Ontario, this affects a lot of people. So what we've got is something called the Ontario Heritage Act. And it first came into being around 1974. I think it was passed that year, and it took effect in 1975. And for the purposes of today's talk, there are two major parts to this statute. Part 4 is the conservation of property of cultural heritage value or interest, and this part applies to individual properties. And when a municipality wants to designate an individual property as a heritage property, it has to publish notice of its intention to do so. It has to serve notice of intention to do so on the owner of the property and publish it in a local newspaper, and that is notice in advance. And the owner can file a notice of objection if they object to being designated a heritage property, and then the objection gets heard by a review board. And the review board has to hold a hearing to determine whether the property should, according to the statute, be designated. But the statute is silent about the criteria that the review board is supposed to look at in determining whether the property should or shouldn't be designated. Now, my guess is that all the review board thinks it's supposed to do is consider whether the property really does or doesn't meet the criteria of being a property of cultural heritage value or interest. I doubt whether their word should encompasses things like, should we force an individual to surrender partial control over his property to a bunch of bureaucrats? My guess is that they won't deal with that issue. But if a property gets designated, either through lack of any objection or because they've made an objection and the objection is dismissed by the review board, then the consequences are that the owner can't alter the property, and I quote, in a manner that is likely to affect the heritage attributes, close quote, unless he gets the consent of the municipal council. Now, the heritage attributes for each property are supposedly spelled out in the notice that's given to the property owner before the designation is made. So if you're the owner and you want to make an alteration, you can take your chances and hope that your alteration doesn't engage the heritage attributes that you were notified of, or if it does engage those heritage attributes, that it's not likely to affect the heritage attributes. But the safest thing to do is always, if you're going to alter your property once it's been designated, get the council's permission. Otherwise, they can charge you with an offense. And I'll talk a bit more about that later. The second important part of this statute is Part 5. And this is called the Heritage Conservation Districts part. And this one allows the municipalities to designate whole swaths of property as one huge heritage conservation district. So this, whoops, didn't give me my second thing in there. Okay, it applies to multiple properties, and I don't know why that didn't advance properly, but. So there's no limit on the number of properties that can be swept into a heritage district. The first thing that the council has to do if they want to create one of these districts is they have to do a study, and then they can pass the bylaw. But there's no need for them to give notice to anybody in advance. They don't have to give notice to the property owners in advance. So even though they are communicating with all of the property owners in the district at least 3 times a year because they send them their bills for their property taxes, they don't have to include any notice in the property tax bills. What they do have to do is make sure that the official plan for the municipality permits it to designate heritage conservation districts. But my guess is that these days, almost every official plan that's adopted by any municipality would have that power in it, because I'm sure that these guys who draft official plans all go to conferences and they get checklists of what to include. So they probably all include the power to create heritage conservation district. So none of the property owners have to be notified until after the bylaw has been passed, so it can be a fait accompli. And at that point, then they have the right to file a notice of objection, and if they do object, any one property owner can trigger a hearing by the Ontario Municipal Board. But as before, the law doesn't set out any grounds for the Ontario Municipal Board to issue its ruling on. So the statute is completely silent about what the Ontario Municipal Board is supposed to decide. All I know is that the one time that I have seen one of these hearings argued, where someone was objecting to the designation of a district, the OMB chairman kept saying, that's not within my jurisdiction. No matter what objection the person raised, she said, that's not within my jurisdiction. That's not within my jurisdiction. So I don't know what she thought her jurisdiction was, and that decision is still pending, and we'll find out when that gets handed down what she thinks her jurisdiction was and what her decision is. But in these district designations, unlike the individual property designations, there is no provision in the statute for any property owner to ask for the bylaw to be repealed later on. So if you've been designated under Part 4 as an individual property, you can come along later and ask them to revoke the designation. But if you're in one of the group that's been designated as a group, there's no provision in the statute for you to come along and ask for it to be repealed. And as with the individual designations, it's an offense for anyone who owns a property in the district to alter, and I quote from the statute, any part of the property other than the interior. Which is a strange way of putting it. I don't know why they can't just say the exterior. I'm not sure whether there is something in between the interior and the exterior that you also can't alter, but anyhow. You have to get permission. If you want to make any alterations to the outside of your property or to the middle layer, I guess, anything other than the inside, you have to get permission from the council. And, okay. There are actually now in Ontario 113 of these heritage conservation districts that are actually in existence, and they encompass more than 6,000 buildings. So you're probably wondering now how the CCF is going to get involved with this issue, and this is where these people come in. This gentleman is Paul Adamthwaite in Picton, Ontario, and his wife Betty Ann Anderson. And Paul runs an organization called the Naval Marine Archive, the Canadian Collection. This is part of an international archive on marine and naval subjects, and he's the keeper of the Canadian branch. And Betty Ann runs a separate charity that collects and conserves marine art. And these two organizations are dedicated to preserving history and heritage. That's their raison d'etre. And their collection includes thousands of books and all kinds of works of art. If you go into their building in Picton, there's model ships all over the place and ships in bottles and all kinds of really interesting stuff. This is a place where they genuinely love history. And apparently researchers come from all around the world to do research in these books that they have in this archive in Picton, because apparently they're not available anywhere else. And Scott, actually, there's some books there that would really interest you. It's about that 1837 rebellion. There's this little collection of about 10 books that I've never heard of anywhere else, but I'll bet you would be interested in that. And this is the building that the archive is in. This is 205 Main Street, Picton, and the building is actually called The Victory. It's gone through a number of different incarnations. At one time it was actually the Picton Post Office. And when the Naval Marine Archive bought it several years ago, this building was a real mess. The roof had been leaking and it hadn't been well maintained at all. And so Dr. Adamthwaite did a lot of work on restoring it, and he went out of his way to preserve its historical character. But now he finds that in the summer of 2013, the municipality of Prince Edward County, where Picton is sort of the county town, suddenly passed this bylaw. So not this past summer, but the year before. And this is the first page of the bylaw, and it's 91 additional pages long. And they declared 12 blocks of the main street of Picton to be a heritage conservation district. So this is page 2 of the bylaw, which is a map of Picton. And you can see there's this dark band down the middle of it. That's the main street of Picton that has now been declared a heritage district. And some of the properties that are included in this zone are rather surprising. So we have, for instance, in Picton, a heritage laundromat and pizzeria. And I just learned how to put a laugh track on the PowerPoint. And we have another newly minted heritage building here, which is the gas station. And personally, even though this gas station is called Pioneer, I don't think that's sufficient to make it a heritage building. And then we have this heritage property, the Kentucky Fried Chicken. And here's the heritage McDonald's. And here's one of the heritage vacant lots. So altogether in this heritage district, there's 142 properties.
So does that mean you can't build a building on there?
Well, you can't alter the exterior.
You can't alter the interior.
You can alter anything but the inside, so I don't know what that means. Obviously, you'd have to get permission. Somebody who wants to build. And what's actually happening, I think, on that particular lot is Shoppers Drug Mart wants to put a building there.
Right.
And I know that they were interested, and they've backed off. I'm not sure what the status of their negotiations with the county are now, but maybe they've just said, oh, the hell with you. We don't need to have a store there. I'm not sure. But in the 142 buildings in Picton, there's 2 supermarkets, 3 gas stations, 2 large vacant lots, and a number of fast food restaurants. In fact, our clients counted 57 buildings of the 142 that were included in this district, but they have no heritage features whatsoever, even according to the municipality's own study. But they just got roped in with a bunch. So, what's wrong with this legislation, and why are we concerned? Well, you could say that there's 2 sets of problems. One is a technical set, in that there's reasons why this legislation would be very difficult to comply with. But more important, there's a philosophical or policy set of reasons why the legislation, we think, not just the bylaw, but the legislation should never have been enacted in the first place. And why we're planning things, when we do proceed with our challenge, it's going to be not just the Picton bylaw that we're challenging, but we're probably also going to end up challenging the legislation. So those are the problems that I want to focus on for the rest of my presentation. And the first one is that these heritage designations are tantamount to partial expropriations, because eventually they're going to reduce the value of the property, and they provide for no compensation for the lost value. So the law says that the owners can't make exterior changes to the property without getting permission from the municipal planning department. Now, there are some exceptions, but the exceptions themselves are described so vaguely that you can't tell whether what you're planning to do is within the exception or not within the exception. So you still need to always consult with the planning department before you do anything. And what will actually happen is when the owners of these properties go to sell them and potential purchasers find out that there is a bunch of extra red tape attached to doing anything with their property, there'll be a certain percentage of potential purchasers who will just say, I don't want the hassle, and they'll drop out of being potential purchasers. So the potential, the marketplace for these heritage properties will be smaller than it otherwise would be, and therefore the sellers can expect to get a lower price. And this is just an example. I found this photo of two properties in a paper that was published by a real estate lawyer who was telling title searches, how to do searches of heritage designations. So these two neighboring properties, the two houses appear to be pretty much identical on the outside, except one has a heritage designation and the other one doesn't. So all of the things being equal, if you were interested in, if you were in the market for a house like this, I think you can see you'd be more inclined to buy the one where you had control of the property rather than the one where you'd have to get some bureaucrat's approval. Law professors often speak of property rights as a bundle of rights. And one of the rights that you normally have in your bundle when you own a building is the power to decide what the exterior of the property will look like. So with this bylaw, the municipality is taking that right out of your bundle and keeping it for itself. So your bundle of rights is now smaller and therefore less valuable. And the legislation states explicitly that no compensation will be paid. So it seems pretty clear that when they wrote this law, they knew that they were going to be reducing property values, and they chose to deliberately override any possibility of anyone claiming right to compensation. Because the state of the common law in Canada is that no compensation has to be paid for an expropriation if the legislature has clearly stated that the property can be taken without compensation. I see your hand, but I'm going to ask you to wait until the presentation is over. Okay, so back in June, when Paul Adamthwaite actually appeared representing himself before the Ontario Municipal Board, this was before the CCF formally took on this case, I heard the opposing lawyer tell the Ontario Municipal Board that contrary to what I've just said, and contrary to popular belief, the price of heritage properties does not go down when they're designated, but actually goes up. And he didn't give the source for this surprising information, so I had to do some research, and I came up with a study here by a guy named Robert Shipley. Now, Shipley is a professor in the School of Planning at the University of Waterloo, Ontario. And I'm going to quote a little bit from this study. It was found that heritage designation could not be shown to have a negative impact. In fact, there appears to be a distinct and generally robust market in designated heritage properties. They generally perform well in the market, with 74% doing average or better than average. And the rate of sale among designated properties is as good or better than the ambient market trends, and the values of heritage properties tend to be resistant to downturns in the general market. So this was very surprising to me, and I thought, I've really got to take a close look at what his study actually says to see why he was getting this result. So one of the things I found when I read the whole paper is early on in the study, he says this, quote, "It is also rare for a building to be designated without the consent of the owner. In the case of districts, once designated, any individual owner within the area has the option to exempt his or her property from the provisions of designation," close quote. Now, his paper was published in 2000, and maybe in 2000, he was right about that everybody consented to the designation, and if it was a group designation, they could opt out. But that is certainly not the law today. There's no opting out. There's no asking for a repeal, and it's, these things are not being designated with the advanced consent of the owners. In fact, in many cases, not even with the advanced knowledge of the owners. So if lawyers are still coming before the OMB and arguing that based on Professor Shipley's study, that property values go up when they're designated as heritage properties, based on the fact that, well, he thinks that they can opt out, he's talking about a completely different scenario. If property owners really could opt out, it's just like the law doesn't apply to them at all, so we don't have to worry about this law. But that's not what the law is today. So that's the first problem with his study. But there were other things that I noticed about his study as well. First of all, he made no reference at all to the fact that heritage properties often become eligible for grants. So the Ontario Heritage Act gives municipalities the power to make grants or loans to the owners of designated properties for the purpose of either paying for the cost of alteration of the property or preserving the property in its heritage state. And there's also something called the Community Improvement Plan in the Planning Act, which again empowers municipalities to make grants and loans to repair, rehabilitate, or improve buildings. But there's no data at all in Professor Shipley's study about how much the heritage properties received by way of grant or loan to bring about their improvement. So if they did sell with a higher price, a higher price increase than the average property in that neighborhood, it might well be because the municipality poured a whole lot of cash into taxpayers' money into these properties. And what would really be a useful study would be to find out how much the municipalities actually paid out in subsidies, whether they even got their money's worth in terms of the increased value of the heritage properties. So, for instance, real estate agents always tell you that if you're planning to sell your house, that's not the time to install an in-ground swimming pool in your backyard, because most purchasers won't pay what you pay. They won't increase their bid for your house by the cost of the swimming pool, because people generally don't value the pool as highly as you might if you're going to install it. So that's the kind of phenomenon that I'm talking about. It would be interesting to see, did the municipality throw $100,000 into rehabilitating some heritage home only to see its value rise by $25,000? And then did Professor Shipley come along and say, well, look, this heritage property went up by $25,000, while completely ignoring the fact that $75,000 was thrown into the wind. And there's one other thing that Professor Shipley didn't mention in his study, which is that heritage designated properties are sometimes given special exemptions or reductions from municipal property taxes. I discovered this when I was doing some legal research and stumbled on a case where the municipality was trying to repeal its heritage designation of an individual property, and the property owner was arguing against that, trying to maintain its heritage designation. And I thought, this is really weird. Why would those roles be reversed? So I read the whole case and found out that the reason they wanted to maintain their heritage designation was that they were getting a really big property tax reduction, and so that was the incentive for wanting the heritage designation. So, I mean, this could obviously make a huge impact on the resale price of heritage properties. If your property comes with a much lower property tax rate than the neighboring property, that would make a difference. But the Shipley study makes no reference to that at all. So instead of being, a really valuable thing, this Shipley study has become like some giant urban myth where sophisticated people now rely on it and come to municipal board hearings and say, well, look, property values don't go down, they go up. And here's the study that proves it. But nobody ever seems to look into this and say, I want Mr. Shipley on the stand so that I can cross-examine him and ask him these questions, like, why didn't you look into this stuff? Why didn't you deal with this stuff? So the myth just carries on and never gets challenged. Now, when Prince Edward County passed its bylaw, 93 pages long, it included a page that actually dealt with the financial incentives that could be granted to heritage properties. So in this long bylaw, there is a page that talks about the fact that you might be able to get grants or loans to improve your property. And I guess that was, if anybody was paying any attention to what council was doing, I guess that was supposed to sweeten the deal and make them think, well, this isn't so bad, I can get grants or loans. But what the county neglected to mention in its bylaw, that it's in absolutely no position to be giving away any money right now at all. So according to Quinte News, which is the the news gathering organization that covers Prince Edward County, in an article that they published on September 25th of this year, less than a month ago. Like almost every other community in Ontario, Prince Edward County has a serious infrastructure deficit when it comes to water, sewer, roads, and bridges. The deficit totals almost $700 million. Now, the population of Prince Edward County done in 2011, the last census, shows that the population was 25,258 people. It's a pretty small place, which means that the per person infrastructure deficit is $27,713. Now, just to clarify, I think that figure of 700 million represents what it would actually cost the county if it wanted to put its infrastructure into a good state of repair. I don't think that's actually the amount of debt that it has racked up, but they actually still do have some debt. The actual debt now is about $45 million, which is $1,781 per person. But there is a lot of debt, and things aren't going to get better because the roads are getting pretty bad. So the fact, the possibility of people getting grants for their heritage properties is pretty illusory in Prince Edward County. Okay, the second major philosophical and policy problem that we have with this legislation is subjectivity and vagueness. Heritage is a very hazy concept. I assumed when I first heard about this legislation that the kind of buildings that it was going to cover would be old, at least, maybe at the very least 100 years old. Like, there's sort of a rule of thumb that antiques are considered to be anything that's more than 100 years old. So I expected that the buildings should at least be, fairly old, and certainly I thought that they would at least be older than me. But that hasn't been the case at all. In Ottawa, just recently, they designated a heritage district that consists of a neighborhood of modern houses built in the late 1960s. So, like late 1960s, that's not even 50 years old. And this whole neighborhood has got itself designated as a heritage district. And I think in that case, they wanted it to be designated heritage, and they're probably eligible for a bunch of grants. But just as a really bizarre example, here's a picture of a heritage building in downtown Toronto. This is the Toronto Dominion Centre, which was built in the 1960s. And the TD Centre consists of the three tall black buildings that these arrows pointing to. So that's the TD Centre, and that's actually designated as a heritage building right now. So is it really possible that something so recent is being designated or being protected by a bylaw designed to preserve heritage? The truth is that really now there's virtually nothing that couldn't be described as heritage property. If this can be a heritage property, anything can be a heritage property. So the whole scheme has essentially evolved into just another overlay of regulatory apparatus with one of two purposes. The first purpose is sometimes outsiders who don't own the property will use it to try to prevent property owners from controlling their own property, just because the outsiders want to impose their preferences as to what the property should look like over the preferences of the people who actually own the property. Or secondly, sometimes the owners of the property will actually request designation in the hopes of getting some kind of public subsidy, either a tax cut or a grant, to improve the value of their property. But either way, it's pretty clear that there is now no objectivity whatsoever in determining what can be declared a heritage property or a heritage district. So there's almost no way to argue against having your property declared if some busybody comes along and says, like, I think that's a heritage building. So virtually everything is heritage now. So even though it seems ridiculous that the Picton Heritage District includes a brand new Tim Hortons building, along with the McDonalds and the Kentucky Fried Chicken, maybe that's not ridiculous after all. I mean, we even had a Tim Hortons set up shop in Afghanistan to service the troops there, right? So maybe Tim Hortons really is some sort of national institution that should be recognized as part of our heritage. Like, anything can be heritage now, so who can say what is and what isn't? So a problem related to the subjectivity of the statute is the vagueness of the language that they actually use in the Conservation District bylaw. And here's some of the phrases that are actually used in the Picton bylaw to tell people when they do or don't need permission to make exterior alterations to their property. one phrase is minor repairs. If you're making minor repairs, you don't need permission. A small area of roof shingles, you can replace that without permission. You can repaint portions of your exterior, that is your wooden doors and windows, provided that you use a traditional or compatible color. For example, Canadian historical color palettes. And you can do landscaping provided that it's soft landscaping. Well, what if you guess wrong about what these words mean? So what if you think that you've replaced only a small area of roof shingles so that you didn't need permission, but some bureaucrat from the planning department comes along later and says, oh no, that was a medium-sized area of roof shingles that you replaced, and you're in violation of the law. There's two property owners, or there's two properties that are in the Picton Heritage District that are owned by a father and son who are the owners of a large local hardware store, and they sell paint there. And they've told me that there were actually 55 companies in Canada that manufacture paint, and many of these different companies have, for marketing purposes, something that they call their historical palette or their classical palette. Or worse yet, some companies have both the classical palette and the historical palette. But they're all different, and there's no official historical palette for Prince Edward County. So if you choose to paint your door Somerville Red from Benjamin Moore's historical collection, but the town planner thinks that you should have chosen Onondaga clay, which to me looks identical, from the classical collection, like, do you have to repaint your door, or can you be fined, or what? This leads us to the question of penalties. Do you hear my cash register ring there? The penalties for non-compliance with this act are amazingly steep. I was shocked when I first read this. For most violations, an individual, including the director or officer of a corporation, can be penalized up to $50,000, or up to 1 year in jail, or both. And a corporation, for the same offense, can be penalized to the tune of $250,000. And if what they've done is to actually demolish a building instead of just, not ask for consent to make an alteration, then the penalty is up to $1 million. And on top of that, the municipality can compel the property owner to restore the property back to the way it was, and to pay the cost of that as well. So there have been some cases already in Ontario where people have been prosecuted. And one example is a company in Toronto that's facing charges right now for allegedly demolishing a building on Queen Street without proper permits. Now, the building has been demolished, and the owner of the company says that they had the proper permits, but they've been charged, so I'm not sure what's going on there. But the owner has told the newspapers that there had been a fire in the building before they bought it, and they bought the building when it was in a distress sale, and it was in derelict condition when they bought it. And then they held on to it for 3 years and negotiated for a demolition permit. And they say they got the permit. I don't think they're fools. They told the Toronto Star, it's not like it was a pristine historical building and we decided to take it down. It wouldn't have served my purpose to demolish a building that was in good condition, which makes sense, right? Like, nobody takes down a good building unless there's something, nobody takes down a building unless there's some good reason for it. But there's a town planner who doesn't agree with that reasoning. Her name is Catherine Nasmith, and she's the president of the Toronto Architectural Conservancy. And of course, they have no skin in the game. They don't own any of the property. They have nothing to gain or lose by this. But she said to the Toronto Star, quote, "It's a shame. These buildings," she said, "it's the kind of streetscape that anchors a neighborhood. These buildings, they're so important just for visual cues in the city. They give a real sense of place. They're impossible to replicate. They give Toronto its character. People can't move in, set up business. People move in. My typeface is way too small for me to be reading from here. People move in, they set up business, they rejuvenate the neighborhood. A new development can't make that happen." Really? Well, she's saying basically new businesses can only set up in old buildings, not new buildings. That's the first time I've ever heard that theory. But she seems to be one of the people who's driving the prosecution of these people. And here's another example. This is a photo of a building in Brampton, Ontario, which used to be the Gummed Papers Factory. And the business closed in 2007 after the company went bankrupt. And a year later, the new owners applied for a permit to demolish the building. They wanted to get it rezoned, and they wanted to build residences there. So that came to the attention of the municipal heritage bureaucrat, who immediately triggered a hold by the municipality. But for some reason, I don't know why, the owner went ahead and demolished the building anyhow, and he was charged, and it was pretty clear that he was going to be convicted. So he pleaded guilty, and he was fined $25,000 plus court costs of $30,000. And here's another case. This, in 2001, this is from Unionville, which is part of the village of Markham, Ontario. Yeah. A man named Ardalan Robati purchased this house, and it was located in a heritage conservation district. It had already been declared part of the district. What he wanted to do with his property was to rent it out to tenants to be used as an office building. And apparently he had some clients who were lawyers. So they needed to have some parking space for the lawyers and clients. And so he wanted to pave the backyard, which I gather was previously just a typical grassy backyard. Now, he asked the municipality for permission, and some discussions took place, but they must have turned very unpleasant because eventually it deteriorated into a situation where Mr. Robati was secretly bringing a tape recorder to all his discussions with the municipality and secretly recording all the conversations that they had. Ultimately, he did pave over his backyard, and they charged him with a violation of the Heritage Act. And he went before a justice of the peace, and in his hearing, he asked to play his tape recordings because he was maintaining, I gather, that they had told him at one point that he could do this. But for some reason, the justice of the peace ruled that the tape recordings were inadmissible. I think she was probably completely wrong in that ruling. He was self-represented, didn't have a lawyer, didn't apparently appeal this ruling. And so the Justice of the Peace said, no, I won't listen to that. And she convicted him of violating the act. And he was fined $5,000. And he was also told, you have to take that paving in the backyard and tear it up and put grass back in your backyard. Now, interestingly enough, Mr. Robati has brought a human rights complaint against the municipal council. And he says that they discriminated against him in not giving him the permit that he was seeking. And the newspaper reports say that he was offered an interpreter for the Farsi language. So I assume from that he is Iranian. And that human rights case is still before the courts. But this case is a nice segue to my next policy criticism of the Ontario Heritage Act, because the act is so arbitrary, and it's so much a matter of one person's opinion and personal preferences over another's, that what it does is it undermines the rule of law, and it leads to the rule of men. So maybe Mr. Robati is actually correct. Maybe someone in the Markham Planning Department didn't approve of his application because he's Iranian. But they could hide this kind of irrelevant discrimination behind a facade of heritage rules. So it could be that if Mr. Robati sold his property to someone who wasn't Iranian, the planning department would find some way to accommodate the new owner's wishes to pave over that backyard. So in other words, this type of arbitrary and subjective regulation leads to this phenomenon: corruption. It should be obvious that when you give a lot of power to someone, especially a lot of arbitrary power, Lord Aston's famous dictum will kick in. You'll get a lot of corruption. And this is common knowledge with respect to zoning. I think there's lots of examples floating around. I just had a man call me up last week out of the blue, wanting me to take on some kind of complaint about a zoning situation. He told me this anecdote about a woman who was a farm wife, and the farm property had been zoned into some sort of green belt or something where they couldn't do anything but farm on that property. And then her husband died, and she didn't want to farm, so she sold the land essentially for a pittance, because all she could do was, all that could be done with it when she sold it was you could farm on it, but you couldn't do anything else. So guess what? A developer bought it for a song, and this developer was someone who had influence with the local council, and he got it rezoned, and he's now building 50 houses on it. So, this is a form of corruption, but nobody talks about this sort of thing. Instead, they're probably giving the developer some kind of award for creating jobs or something. And a couple of months ago, I spoke to a Toronto man about the heritage bylaws, and he said that his mother owned a building in Toronto, which had been designated a heritage building as part of one of these districts. And now the planners were interfering with his mother's ability to rent this property, which was, like, I guess it had apartments in the upstairs and a storefront downstairs. And they weren't granting approval to the proposed tenants for the way, the appearance of the store that the tenants wanted to have there. So this man was convinced that one of the planners actually wanted to buy the building himself, or wanted to have the city buy the building, and was trying to drive the price down by making it unprofitable for the guy's mother to own this property and rent it out. I didn't investigate the case in any more detail, but this is certainly a possible form of corruption that these laws could give rise to. Now, as I prepared this talk, I couldn't help but wonder whether perhaps there were some benefits of heritage designation that I was overlooking. So I decided to, Google that phrase, benefits of heritage declaration. And lo and behold, I did find a document, an online PDF document, entitled precisely what I was looking for. It was called Benefits of Heritage Designation under the Ontario Heritage Act. And it's published by the Ontario Heritage Trust. So here are some of the benefits that are listed in the document. First, designation can be undertaken with or without the support or consent of the owner. Next, all that the municipal council has to do is state its intention to designate. This process only requires the drafting of a statement of cultural heritage value and interest, a council motion, and an advertisement in a local publication. Easy peasy. The next benefit they cite is that there is no compensation requirement for an owner of a designated property. And the next benefit is designation can be undertaken quickly. And finally, compared with expropriation or purchase, designation is an extremely cost-effective way to protect a heritage property. Well, all of these things are benefits for the government. None of these are benefits for any private owner. And I never did find anybody who could come up with any benefits for owners other than the grants and tax relief that I've mentioned. So most people here probably agree that we all like to have heritage properties around. Some of these towns are very nice to walk through. Picton is nice to walk through, and it was even before they passed the heritage designation bylaw. People like the ambiance, and they like the sheer variety, the visual variety that comes from having buildings of different ages scattered through the town. So left to itself, I think that the free market would probably provide just that. There'd be a scattering of properties whose owners place a high degree of value on maintaining the heritage appearance of their properties, and they would keep it that way voluntarily. Other people would prefer to demolish and rebuild from the ground up. But suppose in the opinions of some people, there is not sufficient heritage preservation occurring merely if it's left to chance. What could they do if they really want to see more preservation of existing buildings rather than demolition and rebuilding? Well, one thing they could do is they could put their money where their mouth is, and they could buy the property that they think is so valuable, and maintain it as a heritage building if that's what they like. And if they can't afford it as individuals, maybe they could band together and find other people who also value old buildings and buy it as a group. And if they can't find enough people who will willingly put their money into preserving the heritage, then that should serve as a clue that there really isn't genuine support for heritage preservation when the expense is weighed. There's only support for it when the expense is being forced by state coercion onto somebody else's, to come out of somebody else's wallet. But the other option that is a free market alternative is to see if you could buy something less than entire ownership of the building. So it might be possible to negotiate with a building owner to preserve certain aspects of the building's appearance for a fee. So this could be a contract between the owner of the building and the people who want to see it preserved in a particular way. And there's a long history in real estate law of using something called restrictive covenants. And they can be used to influence the use of land in a private, free market way. And restrictive covenants have to some extent been narrowed. The use has been narrowed by court decisions, and it may be that they've fallen out of fashion for that reason. But there's no reason why they couldn't be revived and used in that way. Now, there's one thing that many advocates of preserving heritage seem to overlook when they talk about this whole issue, and that is that Canada's real heritage, which we get from British common law, is all about private property rights. And at this point, I want to bring John Robson in and give his talk from this morning, or they need to hear John Robson's talk, because we have, dating back to Magna Carta in 1215, we had this agreement by the king to restore property that he had stolen from the barons, and John showed you in his presentation this morning, section 28 from the Magna Carta about property not being taken without compensation. And then there's other people in our heritage, John Locke in those years, who's famous for the source of the phrase, the right to life, liberty, and property. In 1765, Blackstone's Commentaries on the Law of England, which is probably best known for that famous phrase, a man's home is his castle. John gave another version of it this morning, I think. And Blackstone noted that the right of the individual to be free from state interference in the ownership of property is an extremely important right in English common law, and that's our heritage. And even as recently as 1960, we had the Canadian Bill of Rights. The Diefenbaker government passed that, and Section 2 of the Bill of Rights recognized that every individual has the right to the enjoyment of property and the right not to be deprived thereof, except in accordance with due process of law. Now, many of us wish that that guarantee in the Bill of Rights had been stronger, and I guess we're going to hear some discussion later on in the conference about whether it's a good thing to incorporate property rights into the Charter or not, but nevertheless, the point remains that our heritage is really one of respect for property rights, and the notion that the state can come along and either prevent or require alterations to property because some so-called expert likes the look of what they're demanding better than the looks of what the property owner actually wants. Well, this is actually a modern notion. It's a status notion that actually violates our genuine heritage. So what we're going to be working at the CCF is, on this Picton case and possibly others, is the goal of bringing back respect for the genuine aspect of our heritage. So just going back to the beginning of the talk, just a reminder that a Highclere Castle here, given a little imagination, the voluntary preservation of heritage can actually work. And then,